is fired up. I just got a little bit of an error message. Want to make sure that that goes away. If you're not a regular of the program, you may know that we multi-stream on a number of different platforms: Facebook, Periscope, YouTube, and so on. We always like to make sure that they don't give us any grief before we get going here. And it looks like we are live, so let's get going. Hello, everybody, and welcome back to yet another episode of Watching the Watchers Live. My name is Robert Gruler. I am a criminal defense attorney here at the R&R Law Group in the beautiful, always sunny Scottsdale, Arizona, where my team and I, over the course of many years, have helped to represent thousands of good people facing criminal charges navigate through the criminal justice system. Unfortunately, sometimes we get bumps in the road in our lives, and good people need help getting through the system, and that's what our team does. Now, I will tell you, over the course of those many years in practice, we have seen a lot of problems with the criminal justice system. I'm talking about misconduct involving the police. We have prosecutors behaving poorly. We have judges who are not particularly interested in a thing called justice, and it all starts with the politicians, the people who write the rules and pass the laws that we have to follow, but they sometimes have a little bit of a difficulty doing the same thing. And so on Watching the Watchers, what we want to do here is shine the big, beautiful spotlight of accountability and transparency down upon the system so that we can help encourage some meaningful change and live better lives in a more just society. Doesn't that sound pretty good? And so today what we're going to be talking about is, of course, the Supreme Court and the election litigation that's going on, because that is really the story of maybe the decade, honestly, is the legal battle that is going on around the world. I've called it the biggest battle in the history of litigation that we've ever seen. And there's a lot of it going on right now, a lot of activity over this past weekend. Today, we're going to talk about a congressman. His name is Mike Kelly. He filed a new request in the Supreme Court. We're going to spend a lot of time dissecting that, because what happened is a response was scheduled by Judge Alito from the Supreme Court. So the Supreme Court is getting a little bit involved now. We want to break down what that is and what that all means. We're also going to talk about this concept of laches. This has been used very recently a number of different times in a number of different courts around the country to dismiss some of these claims, to throw lawsuits out. And I want to dive into that a little bit further, because this petition that's in front of the Supreme Court right now brings up some good points that I think are relevant. I think we're going to be hearing a lot more about laches for the foreseeable future. We have a clip from Jenna Ellis, Donald Trump's, one of his attorneys, who has explained here that they have done a little bit of they've got permission to do an audit into some of these Dominion machines. And we have some interesting news out of Maricopa County. There was a seizure of some alleged voter theft data that was over here in Fountain Hills, not too far from our office. We want to explain what that was, because the dates on that are a little bit questionable. And then the big news of the day is that Sidney Powell has had some difficulties with a couple lawsuits, and she is vowing to appeal. So we want to break that down as well. And we're going to get into it. Before I do, let me give you a quick reminder. If you're not a regular of the program, we go live at this time every day of the week. So now's a good time to subscribe so that you don't miss those shows. We would appreciate a good share from you on Facebook, or just sharing this, to your friends or family, and explaining to them that these are important issues and you want to invite them to come be a part of the show. As a reminder, all of these slides that I'm about to put out we're about to go through are going to be available in our Discord server. So it's a chat room that you can join before and after the show, so that the conversation can continue even though that the stream may end. And of course, we want to have you a part of that conversation. So before we get into it one more time, I want to wish a very happy birthday to our dear moderator at Ma, who is doing an excellent job helping us man the channel and keep things under control. He had a birthday over the weekend, and we want to wish him a very happy birthday. Hope it was enjoyable, and want to thank him for all of his amazing work. So thank you, Mom, and very happy birthday. All right, so let's get into the material. So as I mentioned, we're going to be talking a little bit about the Supreme Court today, because there's a lot of litigation that's been going on around the country, things in federal court, state court, different court of appeals, circuit courts, and so on. But, the Supreme Court is the one that matters. Everybody's been having a lot of fun with these Trump lawsuits and saying, well, the Trump team's won in 39 and 45 and 107. That's great. I mean, he can lose 150 of them. It doesn't matter if he wins in the Supreme Court. Until the Supreme Court comes out and tells us what's going on, all these other courts don't really matter, because they're less supreme than the Supreme Court. And so now we're getting to the point in this entire phase where we're getting real close to the Supreme Court. And I want to show you a screen from the docket. So this is over at the Supreme Court docket. And you can see here the lawsuit says it's Mike Kelly, who is a United States congressman, versus the state of Pennsylvania. And this comes from the lower court. So you may remember on this channel, we've been spending a lot of time talking about Pennsylvania. Even well before the election, we were talking that this was going to be a major problem. And of course it is. So this is an appeal from the lower court, which is the Supreme Court of the state of Pennsylvania. And this was docketed on December 3rd. And then over this weekend, we saw an interesting update. So the application is for injunctive relief, and it was submitted directly to the Judge Justice Alito. Now, he is a pretty conservative judge, somebody who I think has had his eye on this case for a long time based on some of the other orders that we've seen out of the Supreme Court. And then something interesting happened over this past weekend, where he came out and he said that the original deadline for a response. So the way that this works is right now there was a case out of Pennsylvania. You're probably getting a little bit of lawsuit fatigue because there are so many cases going on. It's really hard to keep track, even if you're a lawyer. There's so much activity going on around this country. And so what happened was we learned last week that out of this Pennsylvania Supreme Court, they dismissed a case. So you may remember, let's back up a little bit further. There was a Commonwealth Court case out of Pennsylvania that Donald Trump's team was winning. They actually won that. And the Commonwealth Court said, listen, there's a lot of problems with this Act 77, which is the act that was passed very late. It was actually passed in 2019, implemented in 2020, that caused a lot of these kind of kerfuffles going on out of the state of Pennsylvania. It moved the election deadline, waived a bunch of signature requirement stuff, made a bunch of people who were ordinarily not allowed to mail in their ballots. It kind of made everybody qualified to mail in their ballot. So it changed a lot of the rules at the ground level. And then we have all these problems. Elections the election is a total mess, and there are lawsuits all over the place. So the Commonwealth Court, which is the lowest court, that was the original recipient of the lawsuit, said that there's a lot of stuff here. There's a lot of problems here. This entire Act 77 may actually be unconstitutional according to the Pennsylvania Constitution, and said there is some merits to this lawsuit. Well, the Pennsylvania Supreme Court, the same Supreme Court that came and sort of modified some of the rules on their own outside of the purview of the legislature, then they come through and they say, we're going to take jurisdiction over this case. We're going to take it back into our hands, and we're going to turn around and we're going to dismiss it. And the basis of that dismissal was Laches. And Laches is this concept that is, not often used in law, kind of one of those things you gloss over in law school. But it's this concept that you brought your lawsuit too late. You should have brought it sooner. You waited too long. Therefore, you don't get to wait until you get hurt and then cry foul over spilled milk. You're not allowed to do that. You should have brought your claim earlier, was their argument. And we were pointing out here that doesn't make any sense because it's kind of a double-edged sword. It's a catch-22. You're between a rock and a hard place. If you are filing your lawsuit before the election, no harm has occurred yet because the election hasn't happened. And so the courts would have said, you're not allowed to bring that claim because of standing, and go away. In other words, your case is dismissed. But then they bring it after the lawsuit or after the election, and the judge says, well, you should have brought it sooner. So you can't do anything. The Commonwealth, the lower court said there are merits here. The Pennsylvania Supreme Court said, nope, Laches gone, case is dismissed. And so this appeal that we're talking about is an emergency appeal to the Supreme Court, the highest court in the land. There's nothing higher, not an appeals court like a federal circuit court or anything. It's the Supreme Court. And so this is what everybody has kind of been waiting for. What do the Supremes have to say about this? And in particular, what does Judge Alito have to say? And so what we're going to see on this slide, back to the docket, is the application for injunctive relief was submitted on December 3rd, and it was submitted directly to Justice Alito. And Judge Alito over the weekend had originally set a date that was a little bit further back, and then he accelerated that date for the response. So Mike Kelly, the congressman, submitted the request for an injunctive relief, turns around, and the Judge Alito turns around and he says, okay, we're going to have your responses to me by a certain time, and then he accelerated that. So he made the date sooner, and he put it here on Tuesday, December 8th by 9 a.m. The docket entry was updated literally yesterday on Sunday. And so many people were scratching their heads and saying, wait a minute, that doesn't make any sense, because the judge came out, scheduled a deadline, and then on his own came back and moved that deadline up. And you'll notice that December 8th is a pretty important day. We've been talking a lot about it here. It's that safe harbor deadline for the Electoral College. And so many people were scratching their heads and saying, oh, that's kind of weird. Is he going to, or issue an order tomorrow? Is he going to issue a ruling? Is this going to have some sort of substantive impact on any of this litigation? We don't quite know yet because they haven't filed their response and because today's not Tuesday. And so we'll know more tomorrow as this case continues to develop. But before, in order to make sure that you're familiar with what's going on and how this works, I want to spend a little bit of time talking about the application itself. So on December 3rd, this application for the injunctive relief was submitted, and let's go over and see what that looks like. So this was submitted in front of the Supreme Court. Superior Court's a lower level court here in Arizona. I'm used to saying that. The Supreme Court of the United States of Arizona. It says Mike Kelly, U.S. Congressman, is the applicant. He's suing Kathy Bukvar. You may remember her name. We've been talking a lot about her and the Commonwealth of Pennsylvania. And they're asking, it's an emergency application for a writ of injunction pending the filing and the disposition of a petition for a writ of certiorari. All right, so what does that mean? Right now, there is a couple questions that this lawsuit wants to bring. We're going to get into those. But the ordinary process for getting a case in front of the Supreme Court is to file a petition for a writ of certiorari, which means you're asking the court to hear your case. The Supreme Court just doesn't accept whatever they want. They have the ability, and they very frequently do, deny appeals. People come to the Supreme Court all the time and they get denied. The Supreme Court doesn't hear their case. They just say, we've already heard that issue. This is not an interesting issue. The lower court was right in their holding, and so we're not going to get involved in any of that. And they'll just send that stuff back away from the Supreme Court. But in this situation, because this is an emergency and they're filing for a writ of injunction, they're going to go directly to Judge Alito. And Judge Alito is going to be the one who's going to hear some of this and schedule some of the orders because this is an emergency. Ordinarily, what happens is all of the Supreme Court judges or kind of how they do things behind closed doors, I'm not too familiar with, but, there's some conversations that take place. There's some, this kind of veil of secrecy and privacy. So they get to decide on their own, behind closed doors, what cases they want to accept, and they have conversations about them in meetings and so on. And so you don't really know what that formal process is, but in this situation, they're not having to go through that. That can take a long time. It can require a lot of conversations back and forth, and it's a sort of a weighty process. But here, they're just going right to Judge Alito, and they're saying, listen, this is an emergency. We've got a lot of important deadlines coming up. We need you to rule on this thing. And so we're going to go through this document here so you can understand, because there are going to be more rulings and more outcomes and a lot more going on with this case. So as we get into it, they're going to say here the reason for granting the application. So this attorney is talking about the All Writs Act. It says that it authorizes a justice or the full court to issue an injunction. So here they're asking the court, and they're saying, listen, you have the authority to do this when the circumstances presented are critical and exigent. So you can see that underlined, the first prong. The court can hear this thing if it's critical and exigent. And if you listen to the facts of the case, if you listen to what's been going on, I think that prong is pretty well met. These issues are election issues. They're very pertinent. There's a lot of heat around them. The country really needs some answers on this stuff. So if I were a judge, I would say absolutely it's critical and it's exigent. Number two, the legal rights at issue are indisputably clear, which is a little bit questionable, right? A lot of the lawsuits that we've seen thus far have been sort of dismissed, and a lot of the allegations here have not been resoundingly proven. So indisputably clear, I'm not sure if that prong is necessarily met. But number three, injunctive relief is necessary and appropriate in the aid of the court's jurisdiction. So that's saying that this court, if they get involved and they issue an injunction, it's going to be pertinent. It's going to be very relevant. So that's what the court is, that's sort of the legal standard before the court is going to hear the opinion or hear the case. And I think that largely those are met. The prong number two, whether these legal rights are indisputably clear or not, that is subject to interpretation, of course. The two questions that are being presented in front of the Supreme Court right now at issue are twofold. One, do the elections and the electors clause of the United States Constitution permit Pennsylvania to violate its own constitution? So that's going to be the main allegation here. And we talk about this. We're going to talk about this a lot. So let me just get back into it. I don't need to digress on it. Number two, do the First and 14th Amendments to the U.S. Constitution permit the dismissal of the claims on the basis of laches? So those are the two questions that this claim has sort of bubbled down, and that's what they're going to be asking Judge Alito to rule on. And we're going to see what he does. Now let's break down this a little bit further. And what he says here is that the Pennsylvania Commonwealth Court is finding that the petitioners were likely to succeed on the merits of the case. So this is a little bit of background here. And remember, the Pennsylvania Commonwealth Court is the lowest level court. So they were finding that they were likely to succeed on the merits. And they even went so far as to issue an emergency preliminarily injunctive relief to prevent the irreparable injury to the petitioners. and all of the Pennsylvania voters. And so the Supreme Court here, rather than provide clarity and address this vitally important, valid constitutional question on the merits, they exercised its extraordinary jurisdiction and they dismissed it on the basis of Laches, which is what we spoke about. This was one of those kind of excuses, I thought, to dump a case that they didn't want to hear from. And this concept that it was Laches, that they brought it too late, this complaint or this petition here is going to really dissect that pretty well, which is why I wanted to spend a little time on it. So it goes on. It says, in doing so, the Pennsylvania Supreme Court violated the the right to petition and the right to due process. So two things here. Number one, when the Pennsylvania Supreme Court stepped in and took away the ability for the Commonwealth, which was the lower level courts. You have the Pennsylvania Supreme Court up here. You have the lower level Commonwealth Court. The Pennsylvania Supreme Court literally just came in and took that case away from the lower level court. They just said, yeah, we see what's going on here. We're going to jump in here and we're going to dismiss the case. This complaint here is saying that by doing that, they violated constitutional rights. Number one, the right to petition your government for a redress of grievances. You may remember that from the First Amendment. And they're also talking about a violation of due process under the 14th Amendment, which is incorporated to the states through that amendment. So due process means that before something happens to you, before you're put in jail, before property is taken away, there has to be process. The government just can't come in and do that on their own. There needs to be a justified legal basis for that. And here they're saying that didn't quite happen. So what they're asking for here is to sort of reverse some of that stuff. They go into the factual background a bit. Let's take a look. It says, in 2019, the Pennsylvania General Assembly desired to implement no excuse absentee voting and initiated the process of proposing the amendment to a Pennsylvania Constitution that allowed no excuse for absentee voting. So I want to pause on this for a quick minute. In Pennsylvania, the Constitution, we're going to get into this, the Pennsylvania Constitution is pretty clear when it comes to voting and when it comes to absentee voting specifically. We're going to learn that it details specific exclusions for what qualifies to allow absentee. In other words, it's kind of default. You go and vote in person if you're in Pennsylvania. If you're not going to go vote in person, you don't get to vote. This mail-in ballot thing is just not one of the things that is in their Constitution. They weren't a fan of it when this was passed. And so as we go through here, we'll see that there was a proposal for an amendment to the Constitution that would allow mail-in voting. This looks like Article 11, Section 1, an amendment to the Constitution must be approved by a majority of the members of both the Senate and the House of Representatives in two separate legislative sessions, then submitted as a ballot question to be voted on by Pennsylvania electors. If after approval, a majority of them vote to approve the amendment, only then will it take effect. So that's a lot there, but basically what that paragraph is saying is it's a big deal to amend the Constitution in Pennsylvania. You have to do a lot. You have to go through, the amendment must be approved by a majority of the members in the Senate and the House in two separate legislative sessions. So not just once, but twice. So in order to amend that, it's a big deal. Then it's submitted. It has to be on the ballot. And the Pennsylvania voters, who are qualified electors, they got to go vote on it. Then after it's approved, then it becomes a constitutional amendment. That's a big deal. And so if the voting rights are defined in the Constitution and the legislature or the governor or the court came in and modified those without a constitutional amendment, well, then they just violated the Constitution, right? Let's go on. It says that the proposed constitutional amendment initiated by the General Assembly has not been approved by a majority vote of both Pennsylvania House and Senate, nor has it been submitted to be a ballot question, nor has it been approved by a majority of the voters. And therefore, it contravenes the Pennsylvania Constitution. And I think this is a little bit about what the Commonwealth was talking about. Act 77, a lot of these new rule changes, they're all in direct contravention to the underlying Constitution. And when Judge Alito said, I think there may be something here, I think this is what he was talking about. He wasn't talking about Dominion. He wasn't talking about software hacking. He wasn't talking about any of that other stuff. He was talking about one government branch acting without authority in violation of the state constitution. Those are the types of claims that the Supreme Court wants to hear. They don't want to hear about somebody in in Venezuela from Hugo Chavez's dictatorship. They're not that interested in that stuff. This is a direct separation of powers question. This is one area of the government stepping on the toes of another area of government, which historically the Supreme Court, they don't like that. They want to keep this stuff separate, as it should be. So the document goes on. It says the Pennsylvania Supreme Court held that the act of May 22, 1923 was unconstitutional because the Pennsylvania Constitution required electors to offer to vote. All right, so let me frame this out a little bit better. I kind of jumped into that. what the rest of this document does is it goes through and it explains a lot of the history of how things work in Pennsylvania. You'll notice that very recently, there's been this big push towards mail-in balloting, and mail-in voting and absentee voting largely is a response to the coronavirus. But coronavirus hasn't been around forever, and there's been a lot of other attempts for people to try to get the mail-in stuff going, to try to get absentee ballots, the rules loosened a little bit. It's been going on for hundreds of years, in particular out of Pennsylvania. So what this complaint is going to do now is just going to carry us through and detail a little bit about how that works. So it says the Pennsylvania Supreme Court held in 1923 that the act that really expanded their absentee voting at that time, they said it was unconstitutional. So they dealt with this just about 100 years ago, and it said that the Pennsylvania Constitution required electors to offer to vote in the district where they reside, and that those who are eligible to vote other than by personal presentation of the ballot were specifically named in the Constitution. For example, active military. So in other words, Constitution says on the ground level, the founding document, the document with the most importance says, you got to vote, offer to vote in the district where they reside, and those eligible to vote by other than personal presentation of the ballot. So other than showing up, giving them the ballot. It's specifically named in the Constitution. And they're talking about active military and those types of things. So what happened here is that they really expanded that. The Constitution keeps it very limited. And many people say, well, that doesn't make any sense. That's kind of, disenfranchising voters, don't you think, if they can't mail their ballot in? Well, there's good reason for this. This has already been decided by this state, by this legislature. The people have already exercised their will. People have already voted on these rules. They've already voted on the Constitution. It's been in place for a long time, and they haven't mustered up the willpower to change it. People know what the rules are, so they can comply with the rules. But here, what we're going to see is that those rules were changed a little bit in a way that didn't work out so well. All right, as we move on, we're going to see the court went further to note, and the court recognizes this. They say, listen, we know that it's not really ideal to throw out a bunch of votes, but this is important. You can't just manipulate the government any way you want. You have to follow the rules. We're a nation of laws. And when you start manipulating the rules and bending things a little bit to serve your will, that's where you run into problems, because now we're all arguing about these recent changes. The court went further, says it noted, however laudable the purpose of the act in 1923 was, it can't be sustained. If it is deemed necessary that such legislation be placed upon our statute books, then an amendment to the Constitution must be adopted, permitting this to be done. This principle was affirmed between 1864 and 1924 in many other states and so on. So this is an amendment. This is a quote from the Supreme Court out of Pennsylvania saying that if you want to modify this stuff, you need to go get an amendment to the Constitution. You can't just change the laws on your own state legislature. You can't just go through and make whatever you want happen. This is defined in the Constitution. If you want to change it, you need a constitutional amendment. Same way that it works in the national scale, right? If we wanted to modify something significant, we have to go through a lot of hurdles for good reason. That's all part of the system. It's all designed that way to keep things stable, to keep things from being messy as they are right now. Literally, this is what the underlying courts were doing for the last 150 years or so. We're keeping things stable. They just changed everything, and now we're stuck in the middle of what kind of feels like chaos for a lot of people. This document goes on. It says the Pennsylvania Supreme Court erred in finding Laches, and this court may review the error because there is a significant federal interest are at stake, and it does not amount to independent state grounds. The Pennsylvania Supreme Court application of Laches was erroneous and is subject to review by this court because there are significant federal interests at issue here. And so two things I want to point out on this. Number one, whether or not there are federal interests at stake here. This is going to be an issue, and I'm not real sure how this one's going to fall out, but the underlying idea is that the U.S. Constitution grants the states the authority to run their own elections. So what is the federal government doing getting involved in any of this stuff? The Pennsylvania lower level court, they've already dealt with it. The Commonwealth said there's an issue. The Supreme Court said there's no issue. Case closed. So why is the federal government getting involved? And the second part is whether there are independent state grounds that would create enough separation between the two bodies. So a separation between the federal court and the state court. And this is going to explore that. So let's dive into it. It says here, such a patent and substantive violation of the Constitution cannot be barred by a mere passage of time. So now we're talking about Laches. And we're talking about these major fundamental rights. So here you can see underlined in red, amending the Constitution to expand a protected and fundamental right is not a mere procedural step, but rather one of substance. So what this complaint is doing, it's distinguishing between a procedural and a substantive issue. The Pennsylvania Supreme Court turned around and found, they looked at the underlying lawsuit and they said, nope, we're not going to hear it on the merits. We're not going to listen to the actual evidence of this case. We're just going to say you can't even bring your lawsuit because you brought it too late. So that's a procedural problem. It's not a substantive issue. They're not even hearing the substance. They didn't hear anything about any of the allegations of fraud. They just said, okay, if you're going to be making a fraud claim and you want a remedy that's going to reverse the election or throw out a bunch of ballots or whatever, too late, regardless of the fraud. And we've seen that around the country. A lot of lawsuits are just being dumped on procedural problems, standing, laches, whatever you want to find. The courts just are looking for reasons to dump these cases. And now they're taking it to the Supreme Court. The document goes on. It says that further evidence of irregular application of laches by the Pennsylvania Supreme Court can be found by examining recent substantive constitutional challenges to legislative enactments in the state. The Pennsylvania Supreme Court, and this is interesting, as recently as 2018, decided to challenge the state's congressional district plan, even though the lawsuit was brought 6 years and multiple elections after the 2011 congressional redistricting. So the map had been changed. There was a lawsuit here, League of Women Voters versus the Commonwealth. Looks like it was settled back on 2018. And so this lawsuit was allowed to proceed forward in Pennsylvania 6 years and multiple elections later. And they didn't dismiss that case based on laches, but they dismissed this one based on laches. See, it seems like a little bit of an unequal application of the rule to me. And this is what you're going to find in a lot of legal analysis. You're going to see this intention to distinguish cases from one another. And you look back at what's called precedent, at all the other cases that have been ruled on by this issue in various courts, and you want to find the cases that support your case and distinguish the cases that don't. And so here, they're finding a case that supports their claim. They're saying, look, you dismissed our lawsuit just this year on laches, but in 2018, you heard a case regarding election litigation, 6 years, multiple elections after the fact, and then you actually ruled on that. So what's the deal? Why aren't you hearing our lawsuit? This goes on, and it says, in short, the Pennsylvania Supreme Court charged the petitioners who had no special knowledge with the failure to institute an action more promptly. Meanwhile, respondents here are going to be the government. They possessed extremely specialized knowledge, and they failed to take any corrective actions. So the people here who were suing, basically Team Trump, they did not hedge their bets. They simply brought an action within mere days of gaining enough information to know that they had been harmed by an unconstitutional election. As soon as they could reasonably have hired counsel to research and identify the constitutional issues, and after they gained standing to bring their claims, they did. They did not even wait for certified election results to confirm that they had been harmed. They just brought the lawsuit. It could not have in any way served the petitioner's interest to delay action even for one day. To suggest they did so deliberately is unsupported. And that's exactly what we've been talking about here. We've been explaining that. They filed these lawsuits quickly all across the country. And many of the lawsuits have been dismissed because they were not very good legal claims. But we were talking about here on this channel that every one is sort of to get an inch. Every single lawsuit, every new claim, every new allegation, they're just fighting for that one little inch. And even if a lawsuit is dismissed, that's not necessarily a bad thing. I mean, you want to win your lawsuits, of course. But when you're filing dozens and dozens of lawsuits in a number of different jurisdictions around the country, well, then that is, you're bound to lose some, and you want to find which claims don't work so well. Which claims are not good? What issues are they going to be responding with? How are they going to be approaching their arguments? And so, many attorneys, you get one crack at it. But when you're talking about a scale this big across the country in numerous jurisdictions with dozens and dozens of issues, I mean, literally hundreds of issues. You got hundreds of affidavits, hundreds of people from different parts of the country, different states, different precincts, different counties that are all experiencing their own issues and their own potential fraud. So these claims can sort of, modulate a little bit. They can morph. They can kind of grow stronger to a certain extent. And these claims are now getting a little bit better. It's sort of like, chiseling a piece of marble. The more you keep chiseling it, the better and better it gets. It's kind of a big, ugly piece of marble at the outside at the beginning, but the more and more work you put into it, you can refine and hone your legal arguments. And so this is where they're at now in front of the Supreme Court, and we're going to hear what the response is tomorrow. Now, the conclusion of this document is as follows. It says, for the foregoing reasons, this court should grant the applicant's request for an emergency writ of injunction or alternatively a lower stay of the court proceeding. So what this means is they want the injunction. They want the court to stop and decertify the lower level election. So let's see what else here. They also want the court to grant certiorari on the questions that are presented here, and they want to treat the application papers as a merits briefing and a merits decision as soon as practicable, which is signed here by Gregory Tufil over in McFarland Street in Pittsburgh, Pennsylvania, who is helping file the claim. So what they're asking the court to do here is say, listen, consider this to be an application on the merits. Issue a decision on the merits as soon as possible. And that's a little bit different. On the merits means that what you're trying to do is you want the court to just weigh the evidence. So right now, as we talked about, a lot of these lawsuits are getting dumped and dismissed because of the procedural problems, the technical problems. They're saying, oh, you brought it too soon. You brought it too late. The electors don't have standing. This person didn't have the ability to bring a claim. The remedy doesn't match the harm, or these sort of technical things. But now what this court is asking, or what they're asking this court to do, is just listen to the evidence. Just take a look at the evidence on the merits and issue a decision on the merits. If you want to dump this because of a procedural problem or Laches or any of those things, you can, but that's not useful. We understand that, but the country needs to know this thing. The Supreme Court, you can give us a lot of help on this. Currently, the last numbers I read, 30% of, I think, even Democrats have questions about this issue. Most Republicans think this is a problem. We're talking, a lot of the country, 70 million people maybe, who think that this was an illegitimate election. So they're pleading with the court, hey, just hear it on the merits. Don't just dump this thing because of a procedural problem, because that's not useful for the country. They're asking the Supreme Court to come in and give us some guidance, and Judge Alito moved up the response day to tomorrow. Wow, so that's pretty soon, and there's a lot of stuff percolating around the country in terms of other lawsuits. Pennsylvania has been knocking on the Supreme Court door. We've been covering Pennsylvania and Buchvar for a long time, and we just wanted to hear what the Supreme Court has to say. And if you remember, we backtracked this thing from before the election. This issue, or these issues about Act 77, the constitutionality of it, what the Supreme Court did to sort of modify everything on the fly, whether that was going to be allowed, it went all the way up to the Supreme Court, was knocking on the door. Amy Coney Barrett was not on the court yet. And so in a 4-4 split decision, Judge Roberts joined the liberals, and they said, we're going to let the lower court ruling stand. So it's going to go back down to the Supreme Court, the Pennsylvania, and they're just going to follow their rules. Well, we all knew this was going to be a problem. Judge Gorsuch, Judge Thomas, and Judge Alito, they all did the same thing. They all knew this was going to be a problem. They even put it in their opinion. Here we are. All back and around we go. We're back in front of the Supreme Court. So we want to see what happens with that. If you're not a regular of the program, click that subscribe button, because it'll be a good time for you to follow along with us as we have more information. So that's what's going on out of the Supreme Court. Now let's turn our eyes to some of the other election litigation that's going on around the country. I want to change gears a little bit. Let's hear from Jenna Ellis about what's going on in Michigan, and specifically in Antrim, about getting access to some of this Dominion equipment. Here is Miss Ellis.
Yeah, well, the big news coming out of Antrim County, Michigan this morning, Pete, is that a judge actually granted our team access to 22 of the Dominion voting machines for us to conduct a forensic audit. So if you remember, this is the county that had this switch of 6,000 votes from President Trump to Joe Biden, and that was an unexplained and so-called glitch. And so our team is going to be able to go in this morning at about 8:30, and we'll be there for about 8 hours to conduct that forensic examination, and we'll have the results in about 48 hours, and that'll tell us a lot about these machines. Yeah.
All right, so that was from this morning. So Jenna Ellis and her team, they are probably literally still checking the equipment. So they're out there doing their forensic audit of the Dominion software. It looks like a number of different machines, and she's promising that we're going to have some answers on that in the next 48 hours. So that puts us about Wednesday this week, which is pretty soon. And, a lot of people are wondering what's going to happen here. Are they going to try to move the goalposts? Are they going to say, well, we're doing another, investigation, and it's not going to come out in 48 hours. Now we're looking at the next 48 hours. We've seen the goalposts move a little bit with the Trump team. Some of it I think is reasonable, some unreasonable, but that's just what happens. And, if they go and they do the audit and they find that it's kind of good software. It's pretty secure. They may try to maneuver things a little bit so that they don't have to come and say that to anybody. Now, I think that it would be very good if they did come back out and say, listen, we checked, it's all good. I would think that it would actually be better for their legal efforts if they came out and said that, because then they could focus on the better claims, which I think are the claims like the ones we just talked about. The idea that the government was literally passing laws that were in violation of their own constitutions, that type of stuff is unlawful. It's unconstitutional. Pretty easy remedy there. If the Supreme Court takes a look at the prior case that we just talked about and they say, listen, that law was unconstitutional. You put it in place, but it's unconstitutional, doesn't stand. Any of the mail-in votes, they get dumped because you shouldn't have done that. It's your own constitution. It's your own rules. The fact that your governor, your secretary of state, your legislature, your Supreme Court, the fact that they all were unconstitutional, that's their problem. You guys need to decide how you want to fix it. So the Supreme Court is not going to come in and step into Pennsylvania and say, all right, all those votes are thrown out or all of these things are irrelevant. They're not going to issue an order like that because the purview of running elections is deemed to the state legislatures. That goes back to the state. And so they could just say, okay, well, we find that Act 77 presents a federal constitutional question because it impacts federal elections. Therefore, we find that act is unconstitutional because it's in violation of your own state constitution because it impacts federal elections. We're going to get involved and dump that. You can't use that. So now you guys, Pennsylvania, you have to figure out what you want to do with it. And the fail-safe, the backup plan that's in our Constitution is that the legislature decides. The election was illegitimate, not credible. So the legislature then would decide, and they could decide, however, to appoint their electors. Now, a lot of this stuff gets really legally murky because it's already been certified. We have, a safe harbor provision coming up tomorrow. We have the vote cast day on December 14th. That's when the Electoral College casts their votes. Then we can fast forward over to January 6th, where they actually open and count the votes on the House floor. So even though these deadlines are coming up, the real hard deadline is that January 6th deadline. So if the Supreme Court comes out and says Act 77 is unconstitutional or a portion of it is unconstitutional, then the remedy would be either the legislature does something to take back the power of appointing their electors, which I'm not sure that they can do, quite frankly. I don't know how that works in Pennsylvania. I don't know their local rules, the legislative policies, or any of those things. But it's sort of irrelevant until the Supreme Court says something. So we can speculate and play that game all day, but until we know what the Supreme Court says, then we can come back out and maybe analyze how they will move forward from that point. But right now, that's one option. The other option would be just to say, all right, we're not going to do anything and just notify the representatives from their state or other representatives from around the country that when the votes are being read on January 6th, that they need to object to those votes. They take a break for 2 hours. They go talk about it. They come back in. If those votes don't count, then Joe Biden drops from 306 to 286 or whatever it is. And if a couple other states fall in this manner, then it would be under the 270. That would trigger a contingent election. They'd go vote. Donald Trump has more states in the House than Joe Biden does because there's more Republican states. What's one path to victory? We'll see what happens. Now, speaking of some of this forensic audit stuff, speaking about the technical components, this data, hacking and all this stuff, we have an interesting story that came out of Arizona today. Investigators seized devices from a Fountain Hills residence in a voter data theft case. This was published couple days ago on December 5th by Jen Fifield and Uriel Garcia. They're both on Twitter. I think I follow them both. And they're writing for AZ Central. It says law enforcement officials served a search warrant at the home of a Fountain Hills man and seized computers, hard drives, and other storage devices as part of an investigation into voter data theft from the Maricopa County Recorder's Office website. Ooh, isn't that interesting? The property was seized on November 5th. 2 days after the election. The search warrant sought records relating to computer intrusion or conspiracy to commit computer intrusion from October 21st through early November. The Maricopa County IT security staff identified the intrusion, according to Megan Gilbertson, a spokesperson for the office. The article goes on. Now, we're going to break down the warrant. We're going to break down the property seizure documents. It says here, analysis by county IT security staff indicates an unauthorized individual gathered publicly accessible voter information from the Maricopa County Recorder's Office website. Additional security protocols were put in place to mitigate against this activity occurring in the future. The Maricopa County Recorder's Office has reported this to proper authorities and law enforcement personnel. There is an ongoing investigation by the FBI at this time. The county is cooperating with the investigation. The property was seized from residents of Elliot Kerwin, identifies himself on LinkedIn as an information technology professional. The FBI did not confirm or deny the investigation and said the agency would have no further comment because that's what the FBI does. They just don't tell us what the heck they're doing, even though it might be good to know whether or not they are, finding any electoral fraud, voter fraud, or any hacking attempts or any of this type of stuff. Would be good to know right now, but they got policies they have to follow. So we'll just let them meander on through it. Now let's go through the warrant itself. This was issued out of the United States District Court for the District of Arizona. And you can see it's looking to search this property, which is over in Fountain Hills, Arizona. It says search and seizure warrant, and it's giving permission for the law enforcement officers to go and search the property. Pretty simple stuff. This means that it was signed off on by a judge. You can see the judge's signature here, and this was issued on 11/4/2020 at 1:24 p.m. Isn't that funny? One day after the election, not even a full 24 hours. A judge signed off on a warrant and said you have to issue and execute this warrant before November 18th, 2020. So they give him 14 days, signed it the day after the election, said go get it, and they went and did it. Now the judge was M. Morrissey here, which is a U.S. magistrate judge. And when we go through the document itself, this is what they're detailing that they want. So the way that a warrant works is, the government needs to go and submit a statement as to what they want, why they want it. It needs to be pretty articulable. They need to have some specificity in there. You can't just say, I want access to your house. What do you want in the house? Well, the whole house. Well, that's not enough. Are you looking for drugs? Are you looking for, child pornography? Are you looking for illegal guns, illegal drug? What is it specifically? And so here they're talking about all of the electronics, essentially, basically anything that's related to technology and electronics, we want it. So in attachment B, they talk about the property to be seized, and it includes anything on the premises, including all computers, tablets, any other electronic devices, routers, modems, network equipment used to connect computers to the internet to commit violations like computer intrusion, conspiracy to commit computer intrusion, and so on. When it goes further, the document says that they want any login credentials. They want any records, information, communications with or relating to the victim's office. They want any information relating to the transfer, the sharing, the dissemination of voter registration records and information, including protected voters' information, records and communications relating to unauthorized access. They want to know whether there were attempts or threats to damage or degrade the victim's computer system. So here the victim would be the government, including through a denial of service attack, malicious software, and other means. They're also going on, they say, we want to know if there's any information about a botnet. Do you have any information, identity, location of any co-conspirators? How about any information related to emails or communication accounts containing any of the communications from any of the data above? So if you did something on a technological device, they want to know everything about it. Any computers stored, saved passwords, usernames, documents, browsing history, user profiles, emails, email contacts, chat, instant messaging logs, photographs, correspondence, and so on, including everything deleted, created, dates, all that stuff is included here under paragraph A. We move on. They want when the computer was accessed. They want to know anything about the user's state of mind as it relates to the crime under the investigation. They want to know about any containers for electronic evidence, counter-forensic programs, and associated data that are designed to eliminate the data from the computer. And it just keeps going on and on and on. You can see here, password, encryption keys, documents and manuals, internet protocol addresses, computer internet activity, contextual information, and then it defines a lot of those records. And so what you see here, this is kind of a standard electronic search warrant, but it's pretty detailed, and you can see they're going to get everything. The judge signed off on it, and it's going to give them access to comb through literally everything they find, and it's going to be curious to see what turns up. Now, let's take a look at the actual property that was seized from this house, and we'll see here there's a lot of it, but not too much. Let's see if they've got anything good here. We have November 5th, 2020, collected and seized from Fountain Hills. We have a Lenovo laptop computer, 120 gigabyte hard drive, solid state drive. Got a Patriot Torch, solid state drive, couple hard drives, Western Digital hard drive, Master Dell, Patriot brand Torch, 128 gigabytes there, 250 gigabytes there. We got two SanDisk, 16 gigabytes, Samsung SD card, a lot of digital storage. We have a black Lenovo ThinkPad Dell computer, USB drives, a bag of USBs, and SD cards. So a lot of those. Red Toshiba hard drive. So a lot of data there. A lot of data capturing. So if you were downloading a lot of voter registration files, I don't know how much data that would be. Probably not that much, I would imagine. But maybe it is. I don't know. But the point here is, this is interesting. And one of the theories that we've been toying around with on this program is this idea that somebody somewhere got a bunch of voter registration data, found out which ones were sort of inactive or not real cognizant. And if they could identify those voters and they could mail a ballot or get them to register for a mail-in ballot or register in their names better, then they could get their ballot, vote it, and manipulate the election that way. And we've talked about that a number of different times. But this could be something as simple as that, or this could be somebody who's just trying to do some innocent research. Remember that a lot of the stuff that we've covered here has been from people who have been scrubbing the data from a number of different websites. I think Matt Brainard bought a bunch of data, so he wasn't scraping the data, but there are other people who've done their analysis by writing these computer programs that are like bots that go onto the New York Times, download all their data, pull it all off, and do some analysis on it. I mean, a lot of information, a lot of these claims about electoral fraud have come from that type of data. So, if this guy was doing something similar to that, and he was just going on and writing a bot that just kind of scraped all the data and organized it for him, that's, in my mind, not that big of a crime. Now, if it is a crime at all, but if this guy who is, if this is something where he's accessing protected data or, breaching programs or breaching security in order to extract protected, confidential, sacred information, that's a whole different ballgame. And the question would be, well, what's he doing that for? Where is that data going? What's the meaning behind it? Who's he working with, and so on. And it sounds like the FBI is taking a look at it, and there's interesting stuff there. The dates are very coincidental. It could just be a coincidental thing. I don't know. Or this means that, they could have been watching him, waiting for him to do something happen. Election day happened, something happened, and then they went and issued the warrant. A lot of speculation right now, but it's one of those interesting stories. We have some documents. We have evidence that there was a search warrant. They seized a bunch of stuff. It's all related to voter data theft, kind of pertinent to what we're talking about on this program. So we will continue to see what happens with that case. It looks like it's sort of happening here out of the district court in the state of Arizona. So right around the corner from us, we'll be paying close attention there. And the final story I wanted to talk about today was, of course, Sidney Powell. Miss Powell had a couple of losses today. Not so good for Team Powell and Team Lynn. Now, they are going to be appealing, but let's take a look at what happened. So this comes from Zoe Tillman, and Zoe Tillman is saying that another loss, this time in Michigan, says this loss is multifaceted. State officials are immune, which is the qualified immunity thing. We've kind of talked about that here. The case is moot. The case is moot. So this is something we're seeing a lot out of a number of different courts as well. The idea that the election is over. The states have already been certified. There's nothing else to talk about. So, sorry, there's nothing we can do here. It's already over. Thanks for playing. I don't think that's the case, right? We have already talked about this, that I think really the ultimate deadline is January 6th. And if these courts came out and said, yeah, we find that there is some fraud here, or they gave any credibility to the underlying claim, then that might change the results of some of these forthcoming developments. This could impact enough state legislature people, state senators, state representatives, enough federally elected state or House representatives. If they see that the court is willing to take action on some of these things, it will give them some legitimacy and some cover to go in and then maybe object to some of the votes being counted from a certain state. So I don't really think it is moot. Technically, according to the rules, the state may have already certified it, but there is still a remedy that's available. So I don't think the case is moot, but I understand why they're bringing those arguments. Laches, they waited too long to sue. We've already covered a lot of that. Abstention because of the state court litigation. So this here is talking about this idea that the Supreme Courts of these states or the federal courts or the 11th Circuit Court of Appeals or any of these Court of Appeals, they're saying that we're not going to get involved. The Constitution says that elections are governed by the legislature, and you didn't file this in state court, which is the court that is involved with the legislature at a state local level. So we can't hear this case. Go deal with it in state court. They also were talking about not having standing. We've seen this one a lot as well. This idea that, you can't sue for whatever you want. You can't sue unless you have an actual harm. You have an interest in the litigation. And a lot of the judges are saying that that's not the case in many of these lawsuits. And so we've covered a number of different formats for how they sue these, some for how they file lawsuits. Some of them have been very just average citizens. I could just go file a lawsuit. Hey, I feel like I was disenfranchised, and I can go file a lawsuit. The court is going to turn around and say, okay, Rob, that's great. Sorry, but you don't have standing here. You're not Donald Trump. You're not running for president. You're not an elector. You're not somebody who's going to go and cast a vote. You're just an average citizen. You have no more standing than the next guy. And so a lot of the dismissals have been on that basis. And then finally, the catch-all, which is here, this unlikely to succeed on the merits, which is something we've heard a lot. And so let's take a look at the Michigan disposition. So this was coming from the U.S. District Court Judge Linda Parker. And this one is out of, what city is this in? I think this is the Michigan lawsuit. Let's take a look at this. She says here, for these reasons, the court finds that plaintiffs are far from likely to succeed in this matter. And in fact, this lawsuit seems to be less about achieving the relief plaintiffs seek as much as goodness, I can't speak. I'm stumbling all over myself today. As much of that relief is beyond the power of this court and more about the impact of their allegations on people's faith in the democratic process and their trust in our government. Plaintiffs ask this court to ignore the orderly statutory scheme established to challenge elections and to ignore the will of the millions of voters. Thus, this court cannot and will not do. The people have spoken. This court denies the emergency motion for the injunctive relief. And so, this judge here, Linda Parker, my understanding is she was appointed by Barack Obama. She puts this in here, the people have spoken. And I love it when judges and prosecutors do this. It's very Hollywood. It's very, the people have spoken, damn it. And it's, I don't know, to each their own on their style. I think it's a little bit over the top, but she put it in there, the people have spoken, which I think is largely something that we're still disagreeing about. Not sure that the people have actually spoken. I think a lot of people have questions about what the people have spoken. And that's kind of what these lawsuits are all about. But she just turned around and dumped this thing. As I said, it's an Obama judge. My understanding is they're going to immediately appeal this. Let's take a look at what happened over in Georgia. Georgia, according to the election wizard, says breaking Judge Batten issues a verbal order dismissing Sidney Powell's Kraken lawsuit in Georgia. So Ms. Faith took this clip, and then we have a little bit of a clip from the oral arguments that took place today because this got dumped literally today right before the show started. Judge says the case should have been brought in state court. Judge also says the plaintiffs should have brought the suit months sooner. So again, two things there, right? They're not going to interfere with the lower level state litigation. Should have brought it sooner. So again, the Laches argument, which we're probably going to get tired of talking about. But here is a little clip from Ms. Powell today. There was a hearing on the motion in the case of Pearson versus Kemp. This was heard literally today, December 7th. Let's take a listen.
To cast ballots that are solely counted based on their voting designations and not on an unencrypted, humanly unverifiable QR code that can be subject to external manipulation and does not allow proper voter verification and ballot vote auditing cannot withstand the scrutiny of a federal court and cannot pass muster as a legitimate voting system in the United States of America. For those reasons, we request the court deny the motion to dismiss, allow us a few days, perhaps even just 5, to conduct an examination of the machines that we have requested from the beginning and find out exactly what went on and give the court the further evidence it might want to rule in our favor, because the fraud that has happened here has destroyed any public confidence that the will of the people is reflected in their vote and just simply cannot stand.
So they want just some additional time to investigate the equipment. Judge says, nope, sorry, not going to happen. The case got dismissed today, it sounds like, but they are not going to stop there. According to the Epic Times over here, this guy, his name is Ivan Penchakov, I think is how you say it. And he does a great job. If you want to follow him on Twitter, he does a lot of these articles. Very, very well plugged in. Email. He's got emails. He's got the news before a lot of other people. So they sent an email over to Sidney Powell today, and she responded saying that they are going to be proceeding as fast as possible to the Supreme Court. So the legal team led by former federal prosecutor Sidney Powell will appeal the dismissal of the Georgia election lawsuit that was dismissed by a federal judge today. The U.S. District Court Judge Timothy Batten dismissed Powell's lawsuit, opining that the plaintiffs have no standing, should have brought the lawsuit to a state court, and had filed the case too late. So kind of the trifecta there. And he says, quote, there's no question that Georgia has a statute that explicitly directs the elections contest to be filed in the Georgia Superior Court. So, maybe they missed that rule. Batten, an appointee of President George Bush, said in explaining his decision following an hour of oral arguments that they are state elections. State courts should evaluate these proceedings from start to finish. So this is kind of the difference between what we were hearing in the appeal in front of the Supreme Court versus this. Here, This district court just dismissed it and said, no, it's the wrong location. It's the wrong venue. It should have been in state court, not in federal court. You didn't have standing. You are the wrong person bringing the lawsuit. So if somebody else were to bring this lawsuit, well, maybe we would hear it, and so on. And so you can see sort of the distinction here. Again, yes, this case was dismissed, but it wasn't heard on the merits. And you heard Sidney Powell in there arguing, just saying, listen, I know they want to dismiss the case. Just give us a little bit of access. Just let us go look at that equipment. And we don't need much time. Give us 5 days. Judge said no. So we'll see what happens. Let's take a look at the super chats and see what everybody is chiming in at. There was a ton of news today, and let's see if we can help decipher some of it. So Wolfgang Deo is here, says, lots of emails. Sorry, would love to see an army of lawyers, reserve units to JAG descend on the land in a hailstorm of lawsuits. I think we are. He says, rebuild Arecibo. Okay, so I think we are kind of in a hailstorm of lawsuits. It's happening all over the country. Really, really a lot going on here. Brendan Cool says, can you do an analysis and breakdown of the 1994 Marks versus Stinson case and for the 1997 Mayor of Miami case and what those tell us about election fraud cases we are following today? So, Brendan, I might be mistaken, but I think we already did talk about Marks versus Stinson on here. I think that might have been the one where the remedy for the lawsuit was to hold a new special election. I forget what we talked about that in terms of what context we had that conversation, but I think we did cover it. I will take a look at them. I'm not sure that I'll do it on the show, but I'll take a look at them. If I think it's relevant and fits with the rest of the program, I'll be happy to talk about it. Wolfgang Deo says, today is Pearl Harbor Remembrance Day. Thanks, Wolfgang, for reminding us of that. We can all just take a quick moment of silence for our fallen brethren and to remember Pearl Harbor. Thank you, everybody. We have another one comes in from Shahin K, who says, do judges consider patterns of evidence? In all the states, they stop counting, ejected observers, mysterious ballots show up, vote spikes for Biden, match the timeline of the mysterious ballots. Yeah, this is a great question, Shahin K. It is yes and no. I mean, the judges will definitely look at, it's called the totality of the circumstances. What is everything going on in totality? And we use this a lot in criminal law where they're trying to justify the basis for an arrest or a traffic stop or whatever it is. And so you can see a lot of that language, but keep this in mind. What we're talking about here are a number of different individual state and local claims. So one court that's, say, in the Commonwealth of Pennsylvania, if the Supreme Court wouldn't have been a liberal 5-2 court, if they would have been, a reasonable court and heard the case on the merits and ruled appropriately, the only thing that they would be able to do is then make an order for Pennsylvania, and they would be able to resolve the state of Pennsylvania case. Now, when you talk about federal courts and you talk about circuit courts, now you start to consolidate the claim. So my point here is that a Pennsylvania court couldn't issue an order that would impact us over here in Arizona. We're too far apart. They have no jurisdiction. They have no authority over the state of Arizona. So their orders would be meaningless here. Now, if you say you want to bubble that up to a higher level circuit, well, you have a number of different circuit courts. Like Arizona, we're in the Ninth Circuit, which means if the Ninth Circuit comes out and issues a ruling, we're bound by that ruling if it impacts us. Okay, and same with the Supreme Court, which governs the entire country. So it kind of depends on what court you're talking about, but it's really a tough thing to do because of the remedy. So if the Supreme Court hears a case that appeals its way all the way up to the top level, typically those are appeals that are coming from individual states. It's like your question is kind of asking, can we see a class action lawsuit with a number of these different states to go to the Supreme Court and say, listen, problems in Arizona, Georgia, Wisconsin, Michigan, Pennsylvania, all of these different states, the cumulative effect is really what we're talking about. It's not all these individual legal claims, but it's a cumulative effect. And, the Supreme Court has the authority to basically do whatever it wants in terms of issuing legal rulings and orders and all of that stuff. But I think what we're going to see instead of that is this really narrow remedy. So when Pennsylvania bubbles up, if they issue a remedy, if they're going to, accept the case, hear oral arguments on it and do something about it, I think their individual claims would just go back down to the individual state. So I'm sort of suspect of the idea that the Supreme Court would come out and just issue a blanket ruling across the entire country because every state is a little bit different. And we've seen that in the various lawsuits. Not all of the fraud claims are exactly the same. Even Sidney Powell, who's making very similar claims, we talked about that last week with the turkey sandwich analogy. She has a number of turkey sandwiches that she's filing around the country. Some of them have mustard and mayo. Some of them have bacon and avocado. Okay, some of them have lettuce, some of them have tomato, but they're all turkey sandwiches. And so the claims are very similar to one another, but they're not exactly the same. And so the Supreme Court, if they wanted to issue a ruling that was a blanket ruling across the country, that doesn't seem so equal. They would need to address each problem individually, and we'll see if that happens. Now, every single one of those cases has to work their way up to the Supreme Court essentially on their own, or the Supreme Court could say, we're going to grant certiorari to a number of these different claims. They could consolidate the cases, issue one order, and say anything that was a violation of this or this is gone. And then that could percolate, or that could sort of transition back down to all of the other different states. Good question, Shahin. Thanks for the super chat and for chiming in. Isaac Castillo says, how do you feel about the decertification rally being held in AZ right now live? Enjoying your content, really informative and eye-opening. Thanks, Isaac. I appreciate that. I didn't even know that there was one going on. I'm not a huge rally type of guy. I don't see a whole lot of benefit to those things. I think it kind of irritates people, and I like the momentum. I like the energy. I like the idea that people are participating in self-governance and all of those things. But myself personally, that's just not something that I partake in. Now, if those people want to go do that, freedom to them to do it. This is America. You have a right to assemble. You have a right to free speech. You have a right to petition your government for a redress of grievances. So I support those things, provided that they're safe and, people aren't burning buildings down. As long as that's not happening, nobody's getting injured, things are peaceful, I fully support that. So Liberty or Death says there also seems to be a circuit split between 8 and 11. How likely would it be for SCOTUS to combine the cases with the Third Circuit case? So offhand, I don't know the 8th, the 3rd cases. It depends on what the nature of the claims are. So I think that the likelihood that what I think Judge Alito is keying into, or what he's looking at here, is the separation of powers issue. Truly, I think that the executive branch here and the judicial branch really encroached on the legislative branch. And if we see a pattern like that in a number of other states, which I think we do, I mean, we've covered a lot of it here. I think in Nevada, they were changing the rules that the legislature set in place. Sometimes those rules are changed by the judges. In Pennsylvania, they just move the election deadline. Sometimes they're done by the election boards themselves. So I think we saw that out of Nevada, where in that lawsuit, the allegation was that the election commission in their rule book, in their manual, was just changing the rules. I mean, the rules were written in stone in the legislature, in state statute. And when they just said, okay, well, now we need to put a manual out in order to train everybody, they just changed the rules in the manual. And then they sent the manual out to a bunch of people, and they just followed the manual. And you say, well, that's not what the law says. You're in violation of the law. And so that's the executive branch encroaching on the legislative branch. And I think the Supreme Court wouldn't take kindly to that. Now, I think that lawsuit ultimately got dismissed, but I think the claim is a good one. That the separation of powers, I think that there's a lot more meat there. There's a lot more weight than you would see in some of these other claims, which are really sort of abstract. This concept that Dominion is, been hacked and has built to hack elections for the last 20 years. The Supreme Court on that, I think, is going to have a little bit of a tough time listening to an expert in a way that would prompt them to make a major change across the entire country. I just don't see that as being realistic. It's a good question, though, Liberty or Death. Thanks for being here. We have Uncivil Law in the house. So I saw Uncivil Law this weekend. Good to see you, my friend. He says, so you think PA Act 77 was unconstitutional? I think it was unconstitutional. Man, everyone disagrees with me. Nate, Nick, and R. Barnes. How about you? So Uncivil Law, based on what I've seen, I think that it is. I mean, it sounds like they're calling it ultra vires, which is this idea that it's outside the scope of the authority of the government. And to me, it seems like it is. We just read through the Pennsylvania appeal today, and it's looking like their statutes, their constitution, not even their statutes, their constitution is pretty clear that absentee voting, mail-in voting is not allowed except for key specific exceptions. And that would include, military people and so on. So if you're just going to expand that on your own to an entire population without going through the formal process that is prescribed under the Constitution, which we've covered here today, yeah, that seems unconstitutional to me. And it stinks. Like, I don't like the idea of having to disenfranchise all those people. I don't like it. But you still got to follow the rules. If they wanted to modify their election rules, they should have done that through the proper mechanisms. You can't just do like a Band-Aid type of government. Oh, COVID's here. We're just going to flip on a bunch of switches and change things at the last minute and see how this all works out, because we're in the middle of how it works out and it's not good. But it's good to see you on civil law. We'll see what happens there. I think Judge Alito might agree with us, my friend. I think he's had his eye on this case for a long time. Even before the election, he issued that order saying that he wanted to hear from them, and then he issued another order saying that he got notified that they weren't segregating their ballots out. So remember, one of the original constitutional questions here was whether the Supreme Court out of Pennsylvania, not the United States Supreme Court, had the authority to change the final election date. So it was on November 3rd. They moved it back to November 6th because of COVID. And my mindset, in my mind, that was unconstitutional. They didn't have the authority to do that. They just did that on their own. And this is going one step further, and they're saying the entire act itself is unconstitutional. But Judge Alito came in and he said, I'm hearing that you're not segregating those ballots, because one of the original bases for getting in front of the Supreme Court was about that deadline. And so he said any votes that came in after November 3rd and before November 6th, they had to be segregated into a different bucket. And that bucket of votes might have been unconstitutional. So we'll see. We'll see what happens. Good to see you on civil law. Lava Java Lava says, if a state claims they're in a state of emergency, are they granted power to change their own elections at will? Well, Lava, it certainly seems that way, doesn't it? Now, that's what a lot of these different governments have been relying on. We've seen governments use all of their emergency powers to shut down businesses, gyms, all sorts of things. And we're seeing that they're using it as an excuse to modify things. And I think even the Supreme Court out of Pennsylvania leaned on that. They said there is some emergency provision somewhere in some statute somewhere that gives us the authority to make emergency changes to the election. That's what their original opinion was based on. But I don't recall exactly what the rationale was. But yeah, they're using it. And the underlying lawsuits themselves, remember, we've talked about this a lot on this channel. Before the election, I think we identified 7 different lawsuits in a number of different battleground states where the Democrats were filing lawsuits all over the place. Most of the underlying litigation came from the Democrats. You can go to the SCOTUS blog and look there. They have a 2020 litigation election tracker. You can go look for yourself. Just click any one of those lawsuits, click it. Well, maybe not now, because now all the Republicans are filing lawsuits. But before the election, it was all Democrats. A lot of Democrats. They were all initiating them. The Michigan Alliance for Retired People, the Georgia Alliance for Retired People, they were all being funded by priorities.org. All the money was going to those guys, filing millions of dollars worth of lawsuits in order to move the rules around, in order to say that COVID was going to be killing everybody and we have to change the election rules. And the courts, the legislature, a lot of people in government just said exactly right. And we saw this, I think, out of another state where they were even telling people that you are what was it? You are permanently and forever, disabled in a way, so that you cannot leave your home. So they were even giving people instructions. The county board of elections were telling people literally, just go to this website. If you need to register to vote, click here to request an absentee ballot. You don't even have to upload your ID. Just skip that box. Don't upload anything there, because we waived that because of COVID, and just upload whatever you want. Get a voter registration. You can all vote absentee, no problem. That person even got reprimanded by the Supreme Court, but it just kept going on. Just allowed to go on. So COVID is an excuse to manipulate a lot of stuff, as we are seeing. We have Zulu, who says, hi, Faith, can we all now agree the states are infantile and how they determine the will of their people should be dictated on a federal level? I don't even know what to say to that there, Zulu. Can we now agree the states are infantile and how they determine the will of their people should be dictated on a federal level? Let me go ahead and just say I would prefer kind of the opposite of that. I think the federal government is a lot more incompetent and infantile than the states are. I would like to see more locality. That's just one man's opinion. I think that the federal government is not particularly good at running a country of 370 million people in 50 states, 3,000 miles apart. 5,000 if you want to include Hawaii and Alaska. It's a big distance. It's a lot going on. I think that locally we know a lot more about how to manage ourselves well, how to conduct our own elections and things like that. And so I'm really interested in seeing this, this movement bubble up from the grassroots to really get out there and encourage the next generation of politicians to revise how we run our elections. Because I think without a free, secure election, every other issue is moot. You can talk about abortion all day long. You can find out which candidate you prefer. But if you don't know that your vote counts to elect that candidate, The abortion issue doesn't really matter so much. It's the foundational, it's the backbone, it's the skeleton of the whole country. We can't just ignore it and wait for the next one to happen. It's not a good idea. And I think it starts local. Lava Java Lava says $4 over with a super chat with a big belly, man. Thanks, Lava. Appreciate it. Catherine Kahn says, thanks for making the legalese palatable. Good to have you here, Catherine. Thanks for being here. We have Jamie Zeluff who says, Rob, don't you think that no court or legislature will overturn out of fear of backlash from the left? I do think that that is a very, very important component to this thing. For a long time after the election, we've been talking about these two things going on. One is the court of law, which we spent a lot of time talking about here, but the other is the court of public opinion. And I think Trump's team has been doing both. They've been fighting battles in both. One has been by lawsuit, by litigation, which we've been covering here. The other is by these legislative hearings. So they're going in front of the people and they're presenting the evidence. They're saying these judges don't want to hear the evidence. No problem. We're just going to take it out to the people. We're going to take it directly to the legislature that is the most closely connected to the people. They're most closely connected to democracy. You know, the ratio of representation is low enough that you actually get some representation from your local legislature. So they're going to the legislature, they're pitching their case, they're making their claims, and we're going to see what happens. Now, I would agree with you. There's a lot to be concerned about. You know, if something happens and Donald Trump is the next president, there's going to be a major backlash across the country. And I think it's going to be a backlash either way. Hopefully we can just keep things civil and move forward, because I think that's ultimately what's most important. But you're right. The courts, the judges, they are people too. And you have to remember, you know, they're thinking about their legacy. They're thinking about their career. They're thinking about their families. And if you see a judge who comes out and says, yeah, we're going to throw out the election, we're going to invalidate 2 million votes, that person is going to have a big target on their back for a long time. And so they would need to have a lot of momentum, a lot of public willpower in order to encourage them to do that. Otherwise, they're just like everybody else, right? You know, judges are supposed to be strong and impartial and unbiased. And that's not the case. They're just people too, like you and me. And if they have the pressure of the governor on their back, or, you know, the Supreme Court or somebody on their back, they're going to do what every human does. They're going to fold to some pressure here and there. So, you know, that's why I think Donald Trump has been trying so hard in the court of public opinion to be very persuasive, be very aggressive with the claims of voter fraud, because he needs the public mindset to shift that direction. If, you know, 10% of the country thinks that there was fraud, there's no point in even filing a lawsuit or any claims there, right? Because it's just not enough. And the judges are just going to dump that stuff. But if it's 40, 50% of the country thinks, hey, maybe there's problems, or it's higher than that, yeah, the judges are going to be more inclined to take a look at it. They're just human, just like everybody else. Ron B says, so if SCOTUS decides to rule on Act 77 and PA case for Trump team, would that have merit in the agreement that GA-Sec of state had with the Dems? So I don't know what the agreement is with the Georgia Secretary of State. Okay, yes, I do. So yes, I do. So this is a great example, Ron. I totally forgot about this. Yeah, there was a settlement agreement between Brad Raffensperger and the DNC. I mean, they came to an agreement before the election to modify all of these different rules. And so one of the main questions here is whether those modifications were ultra vires, whether they were outside of the scope of the lawful authority of those different branches of government. So Brad Raffensperger, Secretary of, I think, State there, or the Secretary of Elections, or whatever he is, you know, does he have the authority to enter into an agreement to change the rules? He can change some of the rules, but what about if he changes the rules that are really baked into the Constitution, or really baked into state statute? Now he is undermining the will of the legislature. The legislature already voted. Those are people, the people already were in office. They already decided the issues. They issued new statutes, and that's it. So for somebody else to take those and say, well, we're just going to interpret them a little bit differently. I know you said that signature is important. We need to verify it this way, but we're going to do it this way because of COVID. And then they take those rules and they change them around on the edges a little bit, and then they implement them. Those types of things, I think, are a violation of the separation of powers. That is the executive branch stepping on the toes of the legislative branch. And I don't think the Supreme Court is going to look too kindly on that. And I think for good reason. Liberty or Death says, Ted Cruz has offered to argue Pennsylvania mail-in ballot case if SCOTUS takes it up. What are your thoughts? I did see that literally on Twitter as I was coming onto the program. Let's take a quick look at it, shall we? Because I pulled it up. And here we can see from Ted Cruz Senate website. Senator Cruz and colleagues submit an amicus brief to the Supreme Court in Brnovich versus the DNC. Brnovich is here in Arizona. The brief seeks to protect the state's authority to ensure the integrity of the elections. So a number of different people: Ted Cruz, Tom Cotton, Rick Scott, Mitch McConnell. Wow, that's a lot of people. James Einhoff. We have Mike Lee. Number of different senators. Today they submitted a joint amicus brief to the Supreme Court. Woo! Okay, I know what we're talking about tomorrow there, folks. In support of the petitioners in the case of Brnovich versus the DNC in defense of the laws that combat the election, the amicus argues that the Voting Rights Act does not prevent states from enacting neutral election integrity measures like Arizona's ban on ballot harvesting, or other measures such as in-precinct voting requirements, voter ID requirements, election observer zones, and straight ticket. The full text may be viewed here, which we will do probably tomorrow. I'm going to read through that. Let's take a quick look. Let's do a little sneak preview on this thing. All right, so we've got our cases here. We just keep scrolling. You can see why it takes so long to kind of go through some of this stuff. All right, so we have the summary of the argument. All right, this isn't a long one, so we'll get back into that tomorrow. Let's see here. In the past few years, many recommended election integrity regulations which impose no more than the usual burdens of voting. They have been challenged in a wave of novel voting rights. Were this court to okay, so we got to read through that because those are just kind of snippets here and there. But that's it. That is interesting. Listen, Ted Cruz, by the way, he is very skilled in SCOTUS. He knows what he's doing. We covered that last week when he was indicating that he might want to join, one of these maneuvers, and it sounds like he's going to do that. I think he was in front of the Supreme Court 9 times, and he won 5, lost 4. Pretty good. It's a pretty good record in the Supreme Court, right? I mean, it's like going to the Super Bowl 9 times and winning 5 of them. It's pretty good. And I don't think there's anybody else in the Senate who has any more experience doing that, and he's got a lot of other senators on back. And this is the type of thing that Trump was really needing. Trump needs some legitimacy from some other branches of government. And we were talking about this a long time ago. He needs somebody from the FBI. I know people don't trust the FBI. I know people don't trust the DOJ. I get it all. But Donald Trump needs something. He needs somebody to lend his team some credibility, because right now it's just him, Rudy, and Jenna all just, shouting voter fraud. Then we have Sidney and Lynn out there telling you not to vote for Republicans. And you're like, what? That doesn't make any sense. So, it's it kind of feels like it's just a couple people floating out on an island when you have a team of 10 senators coming in, or a number of attorneys general, or you have a number of other, other people in the government lending some credibility to your claims. That goes a long way. And now you've got another branch of government getting involved. So now we have the judicial branch, which has been involved for a long time. We have the executive, which is Donald Trump and his team, of course. And then we have the Senate, which is part of the federal legislative branch, now getting involved. So we have all 3 different components. I think that's a big deal. We will take a look and see what happens with that. We have Liberty or Death, who says, does R&R take interns? We do. We do take interns. Why don't you send an email over to us if you're interested in something like that? We do. And I don't know that we have any immediate openings, because I think we have somebody starting in January at the start of the next school year. But yeah, send us a resume if you're interested in doing anything over here. We are always looking for good people. We have Brandon Curtin, who says, what's the process regarding tomorrow's Supreme Court case, and will we be able to hear the rulings, or will that come out in formal statements? So Brandon, it's a good question. And currently it looks like that was just a response deadline. I'm not sure that there are any oral arguments scheduled. I have not seen that. I thought it was just a response deadline. If that has changed, if there is an oral arguments, most of that stuff is not video recorded or anything like that. Oftentimes what they'll do is allow you to call in. Typically, I think those things are pretty difficult to get into because they cap the limit. And so it's a lot of people who are attorneys and legal reporters and all of those things kind of jumping in. You might remember there was a Supreme Court the last time the Supreme Court had phone arguments, or one, I'm not sure if it was the last time, but there was one time very recently where somebody was listening to oral arguments. I think they were working from their homes because of COVID, the Supreme Court judges, and somebody flushed the toilet on the Zoom call, and you could hear it. It sounded like a toilet to me. Now, there was some conversation about that, but people were asking themselves, somebody in the bathroom there on the Supreme Court while they're listening to oral arguments, who knows? We'll see. But we'll know tomorrow. We're going to be covering that tomorrow, so we'll have more information about what happened tomorrow if there are oral arguments. So stick around there, Brandon. Appreciate the question. We have Randolph Schreiner, who says, are there some areas in the country that you don't think we will make any more progress legally? I'm thinking Georgia, Arizona, Nevada, and Pennsylvania. So I think Yeah, I think that's probably true. I'm not so sure that Nevada is going to be one where a lot of energy is being put in, largely because it's just a small state. It's not a big victory. I think it's 6 electoral votes, 9. It's something small. It's not as meaty as some of these other claims. Georgia, I think, is still relevant. Arizona, I think, is very relevant because Brnovich, we just saw, and Ted Cruz and the team of senators, they're going to be filing on behalf of Arizona is what it sounds like. So I think Arizona is still relevant. Pennsylvania is certainly still relevant because it's knocking on the door of the Supreme Court. Georgia, Ms. Powell said that she's going to be appealing her case. I think there's some pretty good issues there. There was another lawsuit we read through where I think there are some good issues about that Secretary of State and the settlement agreement with the DNC, the DSCC, and so on. So there may be one set of cases that move forward a little bit, or there may be one order from the Supreme Court that quashes it all. We'll see. We can say, Sandy H., can we say Trump is trying to steal the election? You could say that, Sandy. I mean, many people are saying that, I would say. Some people are saying that he's trying to execute a coup, and he's trying to steal the country, and he's going to institute martial law and all those things. I don't see any real evidence of that. I mean, I've seen Lynn Wood say that, and I've seen some other weird tweets about that, but nothing from Donald Trump, and I don't think that's realistic at all. I think that if we get through January 6th, if the electoral votes fall in favor of Biden, it's probably going to be it. I think by January 20th, Trump and his crew will have been mostly packed up, and there will be a peaceful transition of power, if that is the case. But if not, well, we'll see what happens. We have Sharon Quidney, who says, why don't any of these judges want to have a trial on the merits? Why won't they at least give access to the evidence? That seems really unfair. It does to me. It seems like it's something like, it's just unfortunate. I think that there is enough here to at least initiate some additional discovery. That's really my issue, is that they're not giving access to discovery and they're not allowing a little bit of a further investigation. I understand why they're doing it. They don't want to open that can of worms. They don't want to give a little bit, because if they give a little bit, then they might find something, and that means they have to go give a lot more. And I think strategically, this has just been something where the courts will sort of entertain it, but they don't want to hear the cases on the merits because it is a big can of worms. And it's messy. And so I think a lot of these judges just want to just kind of punt this stuff down the road, which is not unexpected. I mean, until the Supreme Court comes out and starts clarifying some of this stuff for us, I think these judges are sort of flying blind, a lot of them. And some of it's coming down on political lines. I think a lot of the judges, they're just making rulings based on politics. We see that out of the Pennsylvania Supreme Court on a number of times, and I don't think that they really had a good basis for it. We have Lava Java Lava, who says, great show as always. Have you ever considered having a guest speaker? I have, Lava. It's one of those things where I'm still kind of getting my training wheels off here. The show's just getting a little bit of momentum, and I'm trying to still figure out how I want to structure this stuff and what kind of direction I want to go with the show. So I haven't given a lot of thought to guests, but a lot of people have asked about it, specifically about Robert Barnes and Viva Frey and Nate the lawyer and some of these other guys who I watch. I watch all of them. I was watching Uncivil Law today, this past weekend. In fact, I was watching him, and he was playing a video game called Per Aspera, I think, and I went and bought the game because it looked amazing. So I was like, maybe we can play some video games together. I don't know, but it's something that I have considered. There are a lot of people that I would really, really be interested in talking to. People like Matt Brainard and people like a lot of these other people who are on the ground, who boots on the ground doing the work. I've read a number of lawsuits from some pretty good attorneys, I think. Many of them I'd be interested in talking to, but like I said, I'm still trying to, the training wheels are still just coming off a little bit. So we're trying to feel it out, but I'm going to keep that in mind. And I appreciate the super chats. Appreciate you being here, Lava. We have Essential Hard Worker saying, by saying Laches really shouldn't matter, doesn't that contradict the same as statute of limitations in a lawsuit? If Laches don't apply, then either statute of limitations shouldn't be a law either. Yeah, it's a good question. So these are sort of two ends of the same issue. So for those of you who don't know, a statute of limitations is saying that you have to bring a claim within a certain period of time. Otherwise, you lose the ability to bring a claim. So you see this most often in car accident cases. So if you get into a car accident, say on January 1st, and you bring a lawsuit 2.5 years later, or you try to bring a lawsuit 2.5 years later, that you can't do it because you're out of time. The statute of limitations in Arizona is 2 years. If you bring a lawsuit outside of the 2 years from the date of the accident, you're out of luck. And it's a hard and strict rule. And the reason for that is because they don't want claims to just, pop up 25 years down the road. They don't want to say, oh, my back hurts today. I'm going to sue that guy who hit me 25 years ago. The evidence is bad. There's you had probably a lot of time in between. So you've had a lot of other injuries, a lot of other things. And so the statute of limitations is really to encourage meaningful litigation. It's to encourage it happening soon. But Laches is a little bit different, because Laches is saying you waited too long. You should have brought it before the harm actually occurred. So they're saying you waited too long to file the lawsuit, and now you don't get to bring the claim. It's a little, I'm being very inartful right now in explaining the difference between the two, because it's very, very nuanced. Largely, Laches is not something that we spend a lot of time on in law, quite frankly. A lot of it has sort of been replaced by statute of limitations and some other areas, but I understand your point. The idea here is that Trump's team and his attorneys, they did not have a good option either way. So if they would have brought a lawsuit before the election, they would have no standing, because there would not have been any harm. You remember that, right? So you can't sue somebody before the accident occurs. Here, they can't sue the election board or the government or anybody because there hasn't been any harm yet, because the election never took place. Then they bring it after the election. The government turns around. The courts say, no, you brought it too late. So you're kind of damned if you do and damned if you don't. And it's a little bit different than a statute of limitations, but very closely related. So I understand your point. Statute of limitations, I think, are built for a little bit of a different reason, which it's a good question, and I should have a better answer for you. So let me look into that and explain what that difference is. All right, let me move on to the next one. Dennis Daly, who says, what is certiorari? What does it mean if Alito issues a writ of certiorari, which differ between the WOC? Will we know this week if the SCOTUS will hear? Will star the we? All right, so difficult question. I know that you are really limited on characters in the super chats, but that comes from Dennis Daly. So a writ of certiorari basically means that the Supreme Court is going to hear the case. So you can't just appeal whatever you want to the Supreme Court. You can't just file a lawsuit in the U.S. Supreme Court. They're going to say, okay, that's great. We don't hear those cases. Go file that in state court or a lower level federal court. All right. So a writ is when you're asking the Supreme Court to look at these issues and decide whether the Supreme Court has anything valuable to offer on those. So traditionally what you'll see is, one state sues another state. The Supreme Court needs to get involved to rectify the lawsuits. Or there's a split between the circuits. So the Ninth Circuit handles one issue one way, and the Third Circuit handles it another way, and they're opposite. So now the country's doing two different things. Well, which one is right? And what you'll see is that the other circuits, the Second, the First, the Seventh, the Sixth, they'll all start kind of splitting. One will go with the Ninth, one will go with the Third, and the Supreme Court needs to step in and say, all right, we're going to solve this issue. We're going to consolidate these things, and this is going to be how the whole country is going to handle it. So that's what a writ is, or a writ of certiorari. It's when the Supreme Court says, okay, that's a substantive issue. We're going to hear that. We're going to bring it into the court. We're going to rule on it. And they do it very limitedly. They don't just accept everything. They handle a couple dozen cases a session. It's not a lot, because they want to be very careful and very focused with what their rulings are going to be. So if the Supreme Court ultimately hears it, then we'll get a ruling on it. But we're not there yet. What this order here from Justice Alito is, or what the writ is here for the injunctive relief, is they're saying, listen, tell them to hold off while you decide whether you're going to hear our case. That's all it is. They're saying we have not submitted a writ or a petition for a writ of certiorari. We haven't submitted that yet, but while we do, and while you're considering hearing the case, can you just stop this other stuff from going on? Then we're going to submit it. Then we can have a final ruling on the merits. So it's a preliminary type of maneuver where they're just asking for more time, and they're asking them to stop the certification because of the upcoming deadlines. Good question. Zulu says, a little more flair on the hi, Faith, would be sweet. So Zulu always says hello to Faith. Always. Faith's right back there, by the way. She's amazing. She deserves a nice hello. So if you're in the chat and you want to say hi, Faith, say hi, Faith. Get those fingers going. Warm them up if you haven't been involved. He says, thanks for your consideration, and thanks for agreeing that states are the boss of states. You got it, Zulu. Happy that we're in agreement, because I know that doesn't happen too often. Essential Hard Worker says, you saying Laches shouldn't really apply, doesn't that contradict the law of statute of limitations? It's very contradictory to me, slippery slope. So yes, I botched that. I did not give you a good explanation on that. I understand that totally. It probably does sound contradictory. Laches is a little bit different than a statute of limitations. Largely Laches comes from a court of equity which is a little bit different than a court of law. I could talk for probably an hour on what the distinction is on that and where both come from. And I can't do it right now, but your point is right. If you're going to say that one is not appropriate, I can easily see how you can make the claim that the other is not appropriate. I understand what you're saying, and it's a good point. We have Mahogan Mike who says, hi, your channel is my #1 for info. Mahogan, thank you for that. He says, thanks. If you don't partake in protests and support others' rights to do so, do you think that they are effective? I personally, I don't really, other than I think there are some interesting things that happen there. You meet other people, you get involved in a community. I think that the benefit of going to a protest is you are amongst like-minded people. It keeps the energy up. You want energy behind these things. You can't have a bunch of people who are unengaged in this. This is a big movement. This is a big fight. There's a lot of energy that needs to go in order to maneuver things. And if you don't have that, the movement is going to sort of pitter out. Kind of fade away into the darkness. So protests are good for keeping that energy up. It's also good for public support. I mean, the public sees that and they say, oh, I was kind of mad about that. Those people are mad about that too. Maybe I should do something also. So for them, that may not mean going down and joining the protests, but it might mean sending an email to their legislature, or it might mean, voting in the next election or whatever that is. So I think protests are effective in that way. I personally, I don't know that I would add any value by going down to a protest or participating in one. So I would say that in many ways, this show is sort of like a protest. It's me kind of speaking out in a lot of ways against a lot of the power structure. I typically kind of rail against the government on here, and that's my day job. It's, we have an entire team of attorneys here who go into court, fight for justice, and we're always fighting against the government. We're criminal defense lawyers. We fight the prosecutors, the police, the judges largely. And so that's kind of how we are oriented here. And so from my perspective, that's where I can add some value, is by communicating in this way. I think conversations are probably the most effective way to create some change. It's by taking issues, by exploring ideas, by dissecting what really is going on, by having these long form conversations. I think that's very powerful. And so if those protests are also having those things associated with it, if these people are going for a beer afterwards, or they're going to have dinner, or they're exchanging phone numbers, or they're identifying, new issues that they can sort of rally behind, I think those are very, 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 very productive and probably pretty effective too. But when they cross the border, when they cross that line and they become, borderline violent or dangerous, that's when I think it does more harm than good. And we were seeing that a lot back during the BLM protests. We covered a lot of those here. And, largely, even though I am a criminal defense attorney and I have a lot of issues with a lot of the police, I mean, massive issues, right? I wrote a whole book about helping people defend themselves. But even me, from my perspective, when I start seeing buildings getting burnt down and people getting shot and killed and people getting beaten and sort of knocked unconscious on the streets, you can't support that anymore. Even though I'm all for criminal justice reform, those protests became violent. They became very dangerous. And that type of protesting does a lot more harm to the cause than to the good, than it benefits. And I think there were many people around America, unfortunately, and I say this is such a bummer, who, after they saw George Floyd get killed, they were in line for criminal justice reform. We fast forward a couple months later, suddenly it turns into this defund the police. We want to outlaw law enforcement. We want to disband all of our police officers around the country. And we're going to burn down the buildings and knock people unconscious with skateboards in the middle of the street. That's not a good recipe, not a winning recipe for criminal justice reform. I think it set the cause back, a decade, honestly. Very, very disappointing, especially for somebody like me, who I'm passionate about that. I want to help people get their lives back together, get back on track. And so when we start seeing this mayhem in the streets in the name of justice reform, that is not good. And I really hope that we don't see any more of that. But it's a good question, Mahogan. Thanks for letting me rant on that a little bit. Mike says CDC came out on election day and said that people who have the COVID-19 should go out and vote in person. It's too important. Doesn't that negate what the Dems were arguing in court? Yeah, Mike, there is exactly right. the COVID stuff has been up and down. It's been changed. I can't even count how many times, right? We had wear a mask. First, it was don't wear a mask. Then it's wear a mask. Then it's you got to lock down. Then it's the World Health Organization says lockdowns hurt the poor people. Then it's COVID is aerosolized. Well, then it's in water droplets. Then you can only get sick once. No, now you can recatch it again. Well, now you can't recatch it again. Now you're immune from it. So it's on and on and on and on, around and around we go. But that's not the point. It wasn't even really about COVID. It was about undermining and changing the rules. And I sort of saw this as sort of this orchestrated maneuver because this retired association's people of America were filing lawsuits under their name in a number of different battleground states. So to me, it seemed like it was an orchestrated effort to create some space in the voting scheme. They wanted to muddy it up a little bit so that they could move the rules to their advantage. And they were arguing COVID in court, regardless of really what COVID was doing, because it wasn't about COVID. It was about changing the election rules. And they were very successful on that. Dirk Kessler says, will that guest speaker be Miss Faith? Hi, Miss Faith. Enjoying the video, by the way. Thanks, Dirk. I've asked Miss Faith if she wants to come on the program a little bit. I'm not going to answer for her. Maybe one day. We will see. We have Wolfgang Deo who says, whenever I ask my Democratic friends for a shovel, they ask me back, how much gas you need? Like, I'm just trying to put in a shed, bro. Okay. All right, Wolfgang Deo. Wolfgang Deo. Good to have you here, my friend. All right, let's see what else is going on. Let's hop on over to the YouTube and see what's going on there. Apologize. For some reason, I don't have that chat. Let me see. What would you do if you were Kyle? I'd continue. No, not going to answer that question. How many irregularities? Let's see. All right. Sorry about the delay here, folks. I am just pulling up the chat. And here we are. All right. No, so somebody said something about COVID being a hoax. I don't think COVID was a hoax at all. Let me be crystal clear about that. My family went through a pretty hard COVID summer, and I definitely don't think it is a hoax, but it is something that I think is being, I would say, exploited to a lot of people's ends. One is with the elections. A lot of people are making a lot of money off COVID, and you got to keep that in mind, right? Human beings are rational, self-interested creatures, and people are going to take advantage of changes in the world no matter what it is, whether it's COVID or a natural disaster or all sorts of things. So I think that's to be expected. We say, let's take a look here. We have Cable Box says constitutional scholar argues that the election process is over by midnight on election day. Any state not called by that time is null and void of electors. Do you know anything about this? So yeah, I mean, the Constitution has that type of language in it. Now, it also says that the states can regulate their own elections. The legislatures can regulate their own elections. And so if the legislature wants to make some maneuvers, I think they're allowed to do that as long as it's within compliance of the federal rules, which are set by statute, which we've covered a long time here. There are deadlines specifically ingrained in the Constitution that we have to follow. And if a state doesn't follow that, then that is not allowed. But the bigger issue here is that a lot of the states were sort of changing the rules outside of the constitutional authority to do so. So if constitutionally the states made the changes, I don't think that's a problem. I think they probably could move the election date past November 3rd, provided that they still get their electors nominated, their state certified, all of the ballots transferred over to the federal House of Representatives, and so on within an appropriate timeline. But if they do something that's unconstitutional in changing those rules, which I think is what they did in Pennsylvania, then we will see. All right. We have some other messages. We have Greg in Houston in the house says, would love to see you make an appearance, but as someone that is extremely bashful, I can understand you not wanting to do that. Yeah, Greg, I'm not sure who you're talking about, an appearance on what, but I would entertain it. We have DSF Theater and Real says, this channel is awesome. You and Mark Levin should join the Trump team. I'm a big fan of Mark Levin. Mark Levin's he's a pretty accomplished attorney. Many people don't really know that about the guy. He's pretty brilliant. I've read some of his books years ago, and he's pretty insightful when it comes to this legal stuff. I did watch his video. I think it was released last night. Donald Trump retweeted it. And, it's a lot of the same stuff we've been talking about here. I mean, truthfully, it's a lot of the same issues, a lot of the Act 77 stuff. He brought on somebody with the last name Basham, who is, I thought, very articulate, very good. And his argument was also very interesting. This idea that a lot of the other sort of non-election metrics that we normally look at to see whether somebody would win or lose, they all show that Trump should have won this thing. Largely, we're talking about whether a sitting president gets more votes. If they get more votes, they should win. Trump got more votes, he should win. Whether the bellwether counties, there's a number of these different counties across the United States that vote, the way they vote almost every single time goes in favor of the person who wins. Well, this year they voted for Donald Trump, but he lost. Well, they're bellwether counties. If they were wrong, then they're not a bellwether county. But for the last, 40, 50 years, they've been right every time. So you start to see some of these anomalies, and it kind of is, it's kind of interesting, but that's just tangential. The bigger issue, the underlying point of the entire video was that Act 77 is unconstitutional, and they shouldn't have passed it into law. The Supreme Court shouldn't have maneuvered it. There's a lot of problems, I think, going on in Pennsylvania. And I really think that the Supreme Court is going to have something to say about it. It may not be consequential enough to change course in Pennsylvania, but largely, I can't see that Judge Alito is very happy with what's going on there. Nuno says, why hasn't Kamala Harris given up her seat yet? Doesn't she know already that she isn't becoming the VP? It's a good question. I think that there's probably a good reason for it. I think that she is probably getting pretty good security briefings. She's on the Senate Intelligence Committee, I believe, if I'm not mistaken. And she probably wants that information, and she's not getting access to it because Donald Trump is making the transition a little bit difficult. XCOM 54 says Mark Levin is a law guy. Yeah, he's a lawyer. He is a lawyer. All right. Uncivil Law says you have an invite to come on with me if you want. Love to talk to other attorneys about subjects they are passionate about. All right. Uncivil Law. Let me talk to Miss Faith about that. Maybe we'll get something scheduled. That would be fun. That would be fun. We have Dennis Daly, who says Trump can still win with everything taking place at the joint session when they meet to go count the vote tier Title III USC, that legal. Okay. Let's see. Yeah. We have Lizzie. Lizzie says, if no judge wants to hear the cases, then what is the point? How will faith in the institutions be restored? It's a good question. I mean, if the judges won't hear the case, then the only other remedy is to, act locally, go down to your local state legislature, encourage your people to vote, find people who are running locally who think that election security is a big issue. I think that the next round of candidates, the next people who are running for office, if election security, if election integrity, credibility is not on their platform, that's a pretty big issue. And I don't know how much they should be supported in general, quite frankly, because it is the threshold issue. Everything else is on the back of the election. Everything else. Nothing works if the elections don't work. We have some other questions coming in. Let's see. Biden is being blocked from security briefings. Biden needs to disclose his dealings in foreign countries before he can receive them. At R&R Law Group from Brian Reinhardt, he says, constitutionally, what is the legality of compacts between states? For example, giving electors in accordance to the popular vote instead of the will of the people of the state. So again, those are governed by the legislature. So my understanding is that you don't even have to have a popular vote. The popular vote is something that the states do because it's nice and the people want it. But if the people said, oh, you know what, we don't really even want to vote, we just trust our legislature to do it. Every single year, the state legislature could just go and cast their electoral votes. We just say, we trust you. We delegate that stuff over to you. You go handle it. And I think that would be constitutionally fine. So the argument that Donald Trump and his team have been making, specifically Rudy Giuliani and Jenna Ellis, they've been saying that the legislature can take that power back so they can divest the people of the popular vote. I think that they can. I think legally they have the authority to do that. Now, will they? Probably not, because that would be political suicide. It would cause a lot of unrest. And I don't know that it's the right move for the country just in general, but they could technically. That's the fail-safe. That is the mechanism by which, if there is a problem with the election, voter fraud or whatever it is, that the state can just convene their legislature in a special session. They can go and vote for the next president, cast their electoral votes in whatever manner they want, And that is how we protect ourselves. It is a good question. All right, everybody. Well, let's leave it at that. I want to thank you so much for being a part of the program. Let me run through a couple quick things before we sign off. Number one, I want to thank you so much for being a part of the program. And if you are not a subscriber already, now's a good time to do that because we do go live every day of the week. Now, this week, I'm going to be gone on Thursday and Friday. I know it's terrible. I have to go to this conference. It's been rescheduled, I think 3 times this year. We're now officially going to do it because Arizona is not in lockdown mode, provided that that doesn't happen by next week, which it might, or by Thursday. But I will be there Thursday and Friday, so I apologize, but I will not be doing a show on those days. I will be thinking of you, but I'll be learning a lot, and I'll come back primed and ready to go. I'm in a conference all day, Thursday, Friday, Saturday, and Sunday. It's going to go till 11 p.m. every day. Woo, it's going to be a lot. But we're learning a lot of good things. I'm going to be studying neuro-linguistic programming and different persuasion techniques and all sorts of that stuff. It's kind of a personal development course because many people don't realize this, but when you practice law, it's a people business. There's a lot that goes on there when you're dealing with people. And so we always want to be leveling up those skills as well. While I spend a lot of time studying the law, reading the statutes, analyzing text, and so on, you also want to be developing that other side as well, the people side, because this is a people business. You want to be able to look at a juror and know what they're thinking, how they're feeling, what is their opinion. Look at a judge, look at a cop, whether know whether or not they're being a little bit dishonest or whatever it is. So I'm going to be doing that, but it will be good stuff, and I'll come back and I'll give you an update the following week. Long story. Point is, would love if you subscribed. Would also appreciate a share. Send it to a friend, send it to a family member, somebody who you think would get some value out of the program, or join us. Don't have to agree with me. We want to invite people around the dinner table to have a conversation with us because that's what America's all about. It's about talking about these issues. So we would really appreciate that. All of the slides that we went through today are going to be posted in our Discord server. Miss Faith is back there consolidating the slides, and she's going to add that into the chat. So the Discord server, the link is right in the description below. So if you head on over there, we can chat before and after the show. I do poke in there during the week to just say hi and answer any questions and have a little bit of fun. So come on in and join us there. And as one final reminder, I am a criminal defense attorney here at the R&R Law Group. My team and I, we love helping people. We have an awesome team. We're very passionate about what we do. The same principles that I talk about here: freedom, justice, transparency, accountability. We talk about that. It's sort of embodied throughout the entire firm, and we love to help good people get through the system, get through and get their lives back on track. And we would be honored if you sent us a referral. If you knew anybody who needed our help, we'd love to be introduced to them because we do a great job. We offer free case evaluations. Would love it if you sent them our way. So that is it for me. One more reminder to our very, very good, loyal, trusted moderator, Mr. Ma. He had a happy birthday, so send him a happy birthday and say thanks, Ma, for all that you do on the program. And Miss Faith as well. Another big thank you to her. Without her, the show would not be possible. So thank you, everybody. One more time, hit that subscribe button. Give us a nice like so that this throws the video in the suggested next. The recommended videos would be very, very helpful. Otherwise, my friends, have a very wonderful evening. I will see you back here tomorrow. It's going to be 5 p.m. Arizona time, which is Mountain Time right now. It's going to be 4 p.m. on the West Coast in California. You'll see us at 6 if you're in Texas in Central Time, and 7 p.m. back on the East Coast. Want to make sure you don't miss it because we're going to be talking a lot about the Supreme Court tomorrow is what it sounds like. So I will see you here at that time. Have a wonderful evening. Rest well. Bye-bye.